You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome, listeners, to another episode of People, Places, Planet. I'm your host, Dara Albrecht, and I'm excited to continue our Explain series today. We'll be talking about CERCLA. I'd like to welcome our three wonderful guests, Jack Raffetto, Sam Boxerman, and Mike McLaughlin. Thank you for joining us today.
It's great to be here. Thank you for having us.
Why don't you all go ahead and briefly introduce yourselves?
I'll start. I'm Mike McLaughlin. I'm an engineer and a lawyer with an environmental consulting firm, SCS Engineers, out in Reston, Virginia.
I'll go next. I'm Sam Boxerman. I'm a partner in the environmental health and safety practice at Sidley Austin here in D.C. And my part-time gig, I'm an adjunct professor at the George Washington University Law School, where I've taught a class on CERCLA for the past 20 years.
And I'm Jack Raffetto. I'm also a partner at Sidley Austin in the Environmental Health and Safety Group. And my most time gig is actually dad and part-time baseball coach.
Great. It's wonderful to meet you all. So we're here to talk about CERCLA. Can y'all say a little bit about how your work intersects with the statute?
I began my career before CERCLA was a statute, back before 1980, and actually worked on some Superfund sites back before CERCLA passed. Over the years, I've had the opportunity to work on more than 40 NPL Superfund sites in more than 20 states. And I have a little bit of a feel for how it works in the real world.
I began my career many years ago at the U.S. Department of Justice in the Environmental Enforcement section. And back in those days, CERCLA was really ramping up. So a number of the first cases I worked on were CERCLA cases. And since I've been at Sidley, I've represented clients in CERCLA litigation and advised them in one stage or another the CERCLA process over the last 30 plus years of private practice.
CERCLA was my entree to environmental law when I was a junior associate. I started out doing primarily litigation work, financial services, class actions, which were prevalent back when I started, but always did a little bit of work in the environmental group. Doing CERCLA gave me my first depositions, first trial experience, first mediation experience. And so over a decade of practice later, it's still the bulk of what I do. I really love helping clients navigate interactions with government and other potential responsible parties. And beyond that, I have an environmental practice that involves enforcement, litigation, regulatory advice.
Mike, just to provide our listeners with some context, can you tell us a little bit more about what SCS Engineers does?
Sure. We're an environmental consulting firm. We've got 1,300 people and 70 offices around the country. We have a large environmental consulting practice that includes operating and maintaining pollution control systems, building them, designing them, of course. And we've got a large practice organized around Superfund, doing the studies that lead up to remedial designs, that lead up to remedial construction.
Great. So let's get a little bit into the history of CERCLA before we start talking about it in practice. What drove the passage of CERCLA in the 1970s?
Great question. It's good to start at the beginning. But yes, it was the 1970s that saw a rise of the environmental movement. Congress was very focused on it during that decade. Statutes such as TSCA and RCRA were both enacted during that time, and there were significant amendments to the Clean Water Act, Clean Air Act. It was during the 70s that several highly contaminated sites captured public attention. Perhaps the best known is Love Canal in New York. There's Times Beach in Missouri, known as the Valley of the Drums. And those and other sites led to congressional hearing. That shined a spotlight on the effects of rapid industrial growth of the 20th century in the U.S. It had left waste sites around the country that needed to be addressed. So Congress considered a number of different options for trying to address it. But in December 1980, Congress passed CERCLA, the Comprehensive Environmental Response Compensation Liability Act.
And before we move on, what exactly happened at Love Canal and Times Beach? What made people so concerned about these sites?
Well, Love Canal in particular was located in this small town in upstate New York, and the Hooker Chemical Company had discharged or dumped waste and left it. When the company closed up its operations there, the waste was buried and the property was turned over to the town, who built residential areas, schools, and other community buildings in the vicinity there. And then in the 70s, there were serious health issues that arose in that town. like cancer clusters. And that led to a discovery of the disposal of these chemical wastes and shed a very bright light on historical industrial waste disposal.
Well, I would have said Hooker Chemical did everything right there. For the time, in point in history, it was a lined canal. That's where it gets its name. It had a clay liner, and it had a clay cap, and it had a deed restriction put on the canal. Don't disturb this area. And they sold it for $1 to the town, but they said subject to this deed restriction. And the town, in turn, sold it off for residences, and some pollution started showing up in basements. And the one I know most about is 93rd Street School up there, where kids were discovering black pigment on their clothes as they slid to second base of the baseball diamond at the school.
Thanks for expanding a little bit more about that history. So at a high level, what does CERCLA actually provide for?
I'd like to start with sort of the goals of CERCLA and then put it into categories. Because when I think about CERCLA, I think of the two principal goals that Congress had. One is to clean up sites as quickly as possible. And second is to impose responsibility for paying for the cleanup on the parties that created the problem. I like to refer to that as the kindergarten rule. It was your mess, so you clean it up. Here, we are principally talking about soil, groundwater, and sediment that have been impacted by waste disposal over the years. So to accomplish that at a high level, let's put CERCLA into 4 basic buckets. First, it creates a process for identifying sites. And the trigger in that instance for a site to fall in the world of CERCLA is that there has to be a release or a threat of release of a hazardous substance into the environment that requires a type of response known as a response action under the statute. Then second, the statute provides a framework for deciding which sites demand further consideration, and then investigating those sites and deciding what action should be taken, what level of cleanup might be needed in order to protect human health and the environment. So you identify sites, you provide a framework for deciding how those get addressed. Third, CERCLA defines categories of parties who are liable to pay for or to perform the cleanups. And it gives that power to the president, who has largely delegated those to EPA, to take enforcement action against liable parties. And it's very expansive enforcement power to compel private parties either to perform the cleanups or gives the government the power to go to court to recover the money they spend on a cleanup. And I might add that the statute provides when the government gets recovery of its money, it gets all its costs. It's very clear in the statute. So you have sites being identified, a framework for deciding, a group of liable parties, and then fourth, there are legal rights that these parties have, either to defend themselves against an action by the government or to sort out disputes amongst themselves. So there are 2 other aspects to keep in mind. One is we sometimes refer to this as the Superfund law, and that's because Congress created a $1.8 billion fund at the time the statute was enacted. It was funded through a special tax on oil and chemical companies to fund government actions under the statute. Of course, that amount was not sufficient to address all of the sites. Many, many billions more have been spent. And second, there's a body of regulations that's important to know that guides CERCLA actions. It's known as the National Contingency Plan, or the NCP. That's sort of the basic breakdown.
And then I just have one quick follow-up. So you mentioned the president has largely delegated powers to the EPA. Is that something that is permanent, or can the president sort of recall those powers?
The president can recall those powers. It's just something that the president has delegated many years ago to EPA, but like any presidential delegation, the president has the ability to withdraw that.
That makes sense, and thanks for breaking down the law for me. So how is CERCLA different from other environmental laws?
Unlike other comprehensive federal environmental statutes like RCRA, the Clean Water Act, Clean Air Act, and many others, CERCLA is not a regulatory statute per se. It largely does not prescribe what can and cannot be done by the regulated community or create a permitting scheme that they have to follow. Although I should say that there are odds and ends in CERCLA that do create things like that. But overall, when we're talking about CERCLA or the Superfund, that's not what we mean. Instead, what CERCLA does is it looks backwards and it acts forward. So the law looks to fix contamination left on a site by prior operators or arrangers or transporters so that the site can be returned to a valuable use. CERCLA does that through an enforcement first policy and a polluter pays concept. And the liability is retroactive, strict. It's generally speaking joint and several, and it's spread among a wide swath of parties, different types of relationships to the site.
So I wanted to talk a little bit more about an enforcement first policy and what that means in practice, if you could expand on that.
So when I think of enforcement first, the government is going to come to potentially responsible parties first. The government is going to do some work on its own before that. It's going to identify the site. It's going to start trying to figure out what is going on at that site. Essentially, the choice of the government is, does the government start acting and then seek to recover its costs in the back end, which is inefficient, and it also creates the risk that taxpayers are going to have to foot the bill for the work, or does it immediately go to the potential responsible parties? One of the aspects of Superfund that works well is that there's a lot of incentive for potential responsible parties to come to the table to work together, to work with EPA to try to resolve issues rather than to sit back and try to force the government to make them.
If I could add one thing there. When I think of enforcement first, the idea was that, and has been, that the fund is limited. There's only so much money in the Superfund. And so the government came to that conclusion in the late 1980s. It was going to run out of money. And so it said, you know what? We're going to use enforcement first. We're going to issue orders and make private parties spend their money first. That way, the fund could be preserved for future sites where there weren't private parties. So first, we're going to go after the private parties because we don't have the funds to do all of the sites ourselves.
Well, so how is CERCLA actually enforced?
Well, I think I touched on this a little bit in the past answer, but it bears repeating, which is that CERCLA essentially gives the U.S. government the right to enter sites, to clean them up, and then to sue potential responsible parties to recover the costs. So this creates two potential outcomes for a site. The first is the government cleans up the site using funds from the Superfund and then sues all the potential responsible parties, hoping to recover all of its fees, all its costs. Or the potential responsible parties themselves can step in and tell the government, let us handle this. You'll oversee it. You'll make sure everything we're doing is adequate. And then you don't have to turn around and sue us. So that tends to be the way that CERCLA process works. It bears noting, however, that CERCLA also includes the concept of natural resources damages, which are slightly different. They're federal and state natural resources trustees, often an agency like the Department of the Interior, like U.S. Fish and Wildlife Service. It could be a tribe. It could be a state agency. Those trustees conduct damage assessments and prepare a plan for restoring a resource back to what would have been absent the contamination. And then they turn around and try to recover those costs from the responsible parties. This is not a discussion of natural resources damages, but it's valuable to say that that process looks very different from the CERCLA liability process in terms of the burdens of proof.
I see. And when you're talking about potential outcomes, either the government goes ahead and does the work and hopes to recover the damage later, or the company takes the initiative to do that work. What would be the motivation for a company to take on that potentially hazardous and costly cleanup work themselves?
There are lots of reasons. One reason is maintains a good relationship with government. So very often, a company's liability under CERCLA is a result of many different corporate transactions that led from some small company that doesn't exist anymore, taking the liability of that company all the way forward to a large company that you would notice immediately if you saw the name. And so those companies are repeat players with the EPA, both in the context of CERCLA and elsewhere. And so it's beneficial to maintain a good relationship with EPA by stepping in and doing it. Additionally, private parties are often able to bring newer technology to bear more quickly than EPA. They're able to do the work more efficiently. They're able to have more say in what is going on. They're able to pay more close attention to the particular site to determine if maybe EPA's original plan can be modified to accomplish the cleanup more quickly, more efficiently, and with less cost.
Thanks for expanding on that. Those factors definitely help explain why a company would take that work on themselves. So, which hazardous substances is the EPA concerned with when it comes to CERCLA?
So EPA has a list of hazardous substances that includes chemicals and categories of compounds that EPA will identify under its authority under various statutes. There are also statutory CERCLA hazardous substances that are included on that list. And so when I face the question of what hazardous substance we're talking about here, the first thing I do is I go and look at that list. The way you phrase that question is interesting because I think the question of what hazardous substances is EPA concerned with is actually a slightly different question than what's on that list. EPA has focused on various chemicals over time. For example, in recent years, it has had a particular focus on a compound called PFAS, PFOA. And so that focus can often affect the way that things work at a particular Superfund site or the way the agency engages with a particular Superfund site. And it actually also creates a risk for entities that are involved in the CERCLA process, because you can have a site where you were cleaning up, let's say, chromium and lead, and you finish, and you've been finished, but all of a sudden, one of these new compounds or chemicals that EPA is focused on shows up, and you may have an obligation to come back potentially, depending on how things are done and the consent decree and so on. But there is a risk that people who are involved in the CERCLA practice are focused on when it comes to EPA's focus on hazardous substances.
And this might be a question for Mike, but is this list just based on like the best available science, or what kind of data?
Well, the statute incorporates a whole bunch of other programs. EPA has listed a hazardous substance under the Clean Water Act. That hazardous substance automatically becomes one under CERCLA, and similarly for the hazardous air pollutants under the Clean Air Act and so forth. Now, there are only a few that are actually listed under CERCLA per se. Most of them are done by reference. And just picking up a little bit on one of the things that Jack was talking about, what you don't want to be is responsible for a site where the chemical fits neatly into a headline. Nobody spells out 2378 DCDD. They call it dioxin, which fits conveniently in a headline. And that's an example of one that 30 years ago really had our attention in terms of Superfund site response.
Great, thank you. We'll move to talking about the sites themselves. So how are sites actually identified throughout the country and then chosen for cleanup?
There are actually many ways that a site can come to EPA's attention. It can come from members of the public, simply identifying a property as being one that should be investigated by the agency, or state and local governments may have observations they made about a property or learn information about it, and they'll bring it to EPA. Companies have to provide release reports, and that information can be used by the agency to identify where a release occurred and then indicate to EPA that it requires some further investigation. So once EPA sort of gets this collection of sites, it goes through a screening process. And that process is referred to in CERCLA as a preliminary assessment. It's more of a desktop review to assess whether a site warrants sort of further inquiry. At that stage, if necessary, they may conduct what's referred to as a site inspection. And they'll actually physically go to the property, potentially gather additional information, gather some samples or soil or groundwater if appropriate. And then they'll collect all this information, and depending upon what they learn, EPA will then consider whether the site should be listed on the list of important sites under Superfund known as the National Priorities List, or the NPL. And generally, sites that make it onto the NPL become eligible then for the more in-depth investigation, remedial investigation, feasibility study analysis, and ultimate cleanup led by the EPA. But first, you have to be listed on the NPL. And so a site has to score over a certain value on a system that EPA has developed known as the Hazard Ranking System. And EPA gives each site a score based on certain criteria that are set out in that body of regulations, the NCP. So EPA will look at the actual or potential release of hazardous substances. It'll look at different pathways of exposure. It could be groundwater. It could be surface water, soil, even air and vapor intrusion into buildings are considered. It'll also consider, who may be impacted. What are the receptors in the world of this kind of assessment? Are there people that are impacted or particular environments?
I just want to add one thing to that great description. Oftentimes lawyers tend to think of how can I cut this off at the knees? How can I cut this off before it becomes a problem for my client? And so you can challenge, in addition to the NPL, you can challenge a hazard ranking score. It is extremely difficult, and the number of times it has been successful is very limited. My mentor, Larry Kirsch, has actually been successful a couple times towards the beginning of the CERCLA process, but it just doesn't happen as often. I think when a CERCLA problem comes in, the way that we as lawyers have to look at it is different from the way that other legal matters are viewed.
And that actually kind of leads into my question because I was going to ask if the hazard rankings can change over time, or let's say with PFAS, we didn't really know this was that much of an issue. Well, I don't know how clued in people were to it then versus now, or if we have better science to assess the risk it might pose, or if those rankings can be adjusted, but that's all through challenges.
Just taking it to a little more high level, I think the way that the hazard ranking system works is pretty well set. And I think the scoring is pretty well set, although I think EPA can change it as they change their regulations. The challenges, I think, would be more, you have done this wrong with respect to this particular site. The way that new chemicals or new compounds would come in, I think, would be a little more like, hey, EPA, there's a reason why you should add this to your list of hazardous chemicals. Or EPA just becomes more interested in it and they start to focus on it a little bit more. And so in this ongoing communication about a site, they'll say, well, hey, have you looked for this?
And so you have to score over a certain value. So if a site doesn't quite make that cutoff to be listed on the NPL, does cleaning it up then fall to another authority?
It could. If EPA decides it's not a site of a sufficient priority for the federal government to get involved in, depending upon the state, states have their own cleanup laws, sometimes referred to as mini Superfund laws. And so if a site is important enough for a particular state, they could choose to pick up that particular property and decide this demands our response. And so that is certainly one way that a site could get addressed, even if it's not addressed by US EPA.
Great, thank you. So once a site is chosen for cleanup, what is EPA's process for addressing the sites?
Sam's already talked about response actions, and response actions are two flavors. One's called a removal action, one's called a remedial action. And it's not always easy to tell what the difference is, but in theory, a removal action is something that can be done quickly, relatively inexpensively, and could be consistent with a long-term remedial action. That would be a removal action. An example might be a family coming home from a 6-month vacation abroad, and they discover 50 hazardous waste barrels in their carport when they came home. EPA might decide in a removal action to remove those drums and take them off site for proper disposal. There's not very many rules around removal actions. Again, they can be done quickly, relatively inexpensively. If there are at least 6 months to plan one, you're supposed to put together an engineering evaluation and cost analysis to do at least a little bit of thinking through how the removal might fit in with everything else. And for more complicated problems, relatively more expensive and durable permanent solutions, those are the remedial actions. And those pick up normally with a remedial investigation, a pretty thorough investigation of the affected media at a site, a human health and an ecological risk assessment, figure out what the harm presented by those conditions are, put together a feasibility study to look at what could be done about it, and then select a permanent remedy. And you think about a complicated groundwater contamination site, that would be something that typically would be addressed with a remedial action. And again, the boundary between these two is not all that clear, but maybe get the flavor of it.
Well, one thing to add there, since we talked about the national priorities list, EPA can take removal actions even before a site is placed on the NPL. So if a site presents some emergency or some reason for EPA to desire to act quickly, like Mike's carport example, or it could be any property where there's some identification of an issue that requires a response, even before you go through the whole process of listing a site on the NPL, EPA can take a removal action or order a party to take a removal action. So EPA can get it done expeditiously, going back to that original goal of the statute.
And while we're adding in on that, Mike said that there aren't very many rules about removal actions. But one rule that there is statute of limitations. And it's just a valuable time to say that the statute of limitations for removal and remedial actions are different. Triggers when they start are different. So that's an important thing to keep in mind.
And that's one reason why the boundary between the two is very murky, because fancy, smart lawyers like to argue one way or another, depending on what suits them.
Are these remedial actions always long, drawn-out processes, or are there any exceptions? And how clear is the distinction between the two?
I have seen removal actions that look an awful lot like a remedial action. I mean, a pretty elaborate removal action. That would be an exception to what you normally think of as a removal action. And I've seen remedial actions that happen relatively quickly and simply. A remedial action to dig up just a few thousand cubic yards of contaminated soil and haul it off site. That could be done very quickly. Looks like a removal action, but it actually went through all the remedial action steps.
Whether the remedial or removal actions are elaborate or simple, how is compliance actually measured? And when can we actually consider a site clean enough?
I'll take this one. There is a framework set out in the NCP for setting an appropriate cleanup level and then using that cleanup level to select a remedy to get to that cleanup level. The risk assessments we talked about earlier guide that process, and we know what the danger is presented by the different chemicals that present an unacceptable risk to human health or the environment. But then the NCP lays out 9 criteria that we use to pick our remedial action. All the alternatives have to comply with 2 threshold criteria at the outset. The cleanup has to provide overall protection of human health and the environment. That's one criterion. And the cleanup has to comply with applicable or relevant and appropriate regulatory standards. Another acronym, ARARs. ARARs are site-specific. You don't apply a groundwater ARAR to a site that doesn't have a groundwater problem. And they often involve the state's standards for cleanups. And the idea is to make sure that our remedy lines up with those regulatory requirements. After you clear those threshold criteria, there are 5 so-called balancing criteria that we use. The long-term effectiveness and permanence of the remedy is one of those. The remedy's ability to reduce the toxicity, mobility, or volume of the hazard through treatment, that's a second criteria. Short-term effectiveness, implementability, feasibility, and cost is a criterion, of course. And then the final 2 criteria have to do with public acceptance, both at the community level and at the state level. And if you have a remedy that is pretty similar to another remedy in terms of the first 7 criteria, but the community is more willing to accept it as compared to the other, that'll often be what tips the balance at the end of the day and results in selecting that remedy. One thing that CERCLA does not have is a written down list of cleanup levels. Might be really nice to have those, but it turns out these risks are really site specific, and what's clean enough for one site might not be nearly clean enough for another.
Yeah, like you mentioned, community acceptance could really tip the scales, and you talked about how we have to provide overall protection of human health and the environment. And so I'm wondering, how big of a focus is the community accepting the public health risks in this? Like, do the sites have to say it could pose no threat to human health ever, or is there an acceptable level?
Yeah, there is no way to eliminate all risk. A zero risk is not in this planet. But a very important skill set is to make sure the community understands what the risks are, have a practical appreciation for what those risks are, and how the remedy that's been selected will address those risks in words they can relate to. It's a challenge for the regulatory agency and for the PRPs and their consultants.
There is, in some instances, a rule of thumb that EPA has used saying that if there's less than a 1 in a million cancer risk, that would be considered a site that would present a low enough risk. But it's not necessarily consistent across the board. It's going to vary site to site, as Mike explained. But that's sort of a rule of thumb that the agency has looked at over the years.
Another thing that's worth noting is very often we're talking about sites where there are background levels of contaminant already in the soil and the water and sediment. And so all of these things factor into figuring out how clean is clean. To Mike's point, it really is about community engagement, trying to make sure people understand what the remedy is, how it's going to work.
So, which parties are typically responsible for the removal or remedial action?
CERCLA creates 4 categories of potentially responsible parties, which another great acronym referred to as PRPs. The first is current owner or operator of a facility. So generally speaking, that's the current record owner of the site or the entities that are actually doing things on the site, operating the site on a day-to-day basis. It's worth noting it also can include tenants. So just because you're not the record owner doesn't mean you're not the CERCLA owner. And the second category is the owners and operators at time of a disposal of a hazardous substance. So when we look back in time and we find an owner, just because you're the past owner doesn't necessarily mean you're liable. But if you were the past owner or operator at the time of the disposal, you can be. I think it's really important to understand the distinction between these first 2 categories. The reason that current owners and operators are potential responsible parties, regardless of whether there was a release at the time of their ownership and operation, is because theoretically they're going to get a clean site out of the process. So they have a benefit coming, and so CERCLA generally says you should pay something. Question is how much. If you're a past owner or operator, then the question becomes, was there a release at the time of your ownership and operation? Third category is generators or arrangers for disposal. So the easiest way to think about this is an entity that arranged to or had a contract to dispose of its hazardous substance at a dump site. Lots and lots of cases about that. But it's very fact dependent. You can be a generator or arranger under a wide variety of circumstances. And the last category is transporters. Transporters of entities that haul the hazardous substances to the site for treatment or disposal. However, they had to have selected the sites. It can't be purely passive. They had to have taken sort of that active step of saying, here's where we're going to transport this material.
And why make so many folks potentially liable?
I think it goes back to something we talked about earlier, which is Congress did not want taxpayers to be on the hook for this. Congress wanted the kindergarten rule Sam mentioned. If you made the mess, you have to clean it up. They wanted the entities that were involved to be part of the process and to be potentially responsible for paying for cleanups. The more parties that you have, the less chance that somebody's going to be bankrupt or insolvent or such a small company that they can pay for the entire cleanup. So I think Congress intended to have a robust group of parties to make sure that there's money there to do the cleanup.
Great, thank you. So, are there any defenses to liability?
There are precious few that related on the original statute anyway. Acts of God, acts of war, acts of third parties that are completely unrelated to the PRP. If you have a contract with a third party,
that defeats the defense, and deeds count as contracts. So when you buy a piece of property and you have a contract to do that, you're no longer unrelated. Lost the defense, at least on the original statute. And you can delete these last 15 seconds or so.
So when you buy a piece of property and you have a contract to do that, you lose that third party liability and defense. Over time, Congress has added some other defenses to the statute. In 1986, the Congress added something called the innocent landowner defense. And that means that somebody undertook all appropriate inquiries into the background of the site, went out and looked at the site, and had no reason to think there was anything bad about it. No hazardous substance contamination based on that phase 1 site assessment report. And if you had no knowledge at all, then you could be an innocent landowner. That put a premium on environmental consultants doing phase 1 site assessments sometimes that didn't find an obvious problem with a piece of property. And a lot of clients were kind of putting pressure on, I want a clean report. And you know what that means. And eventually, in 2002, we had some brownfield amendments to Superfund, and that changed things around for the better, at least with respect to these defenses. There's a bona fide prospective purchaser defense and a contiguous property owner defense. And to avail yourselves of those defenses, you had to undertake all appropriate inquiries, a phase 1 site assessment. But if you discovered something, you had to take reasonable steps to deal with that contamination that you found. Not necessarily clean it up, but reasonable steps. And those defenses have a lot more play in the market. There's a lot more availing of those defenses Congress added in 2002.
One thing just to note about that is that the burden of proof for these defenses is high, and it falls on the party that is seeking to avoid involvement as a PRP. And so there are cases where a party meets every single criterion, and then they don't put forward any evidence about whether they have any contractual relationship with the prior landowner. And the court just said, sorry, you don't get the defense. So it's not enough to just say, well, I meet most of the criteria, so I'm pretty much there. You really do have to meet all of the different elements of this defense, which is very difficult.
Yeah, that is really interesting and definitely something to consider. So what tools does CERCLA give the EPA to shift this responsibility for cleanups onto private parties?
There are several tools in the EPA toolbox to think about. Foremost, in my mind, is that each PRP or potentially responsible party is subject to joint and several liability to the United States government. And this, I might add, was not expressly stated in CERCLA. It's come about as a result of judicial interpretation of the law. It's based on tort law principles. So when we say joint and several liability, just as in tort law, one liable party can be liable to the government for the entire cleanup, even if that person only contributed a portion or a fraction of the release or operated the site for a fraction of the time. So consider a large multi-party site, hundreds of parties, let's say 500 parties, 499 of them, very smart. They're off on the beach in Rio, enjoying life. Party X, though, is still here and only contributed 1% of the waste. They are still jointly and severally liable for the entire site. So all 500 parties' responsibilities could be left for that one party by being jointly and severally liable. So with that extremely favorable liability scheme, EPA can complete the cleanup itself and then file a lawsuit known as a cost recovery lawsuit to recover their money under Section 107 of CERCLA. And they don't have to sue every party. They may have identified 500 parties, but they can pick and choose. They can say, we're going to only sue 5. They happen to be the deepest pockets, or maybe they're the largest parties at a site, but they're jointly and severally liable for everything that EPA spends, all of their costs. So it's a pretty powerful tool for the government. They also have the power under Section 106 of CERCLA to issue unilateral orders to implement a response action. And this, we've touched on, is an extraordinary power that's been given the United States under CERCLA because there's no opportunity for judicial review. So if EPA issues an order to me and I think it's unreasonable or arbitrary, I cannot go to a federal judge and ask that judge to say, strike down this order. It's wrong. I don't have that right immediately to go to court. I can say to EPA, I don't think this is right and I'm not going to comply. And EPA then could take me to court. And if it wins, I could be forced to pay EPA civil penalties. They're daily civil penalties that can run very quickly into the millions of dollars. And just like in antitrust law, I could be forced to pay treble damages. So if EPA were to go ahead and do the cleanup and spend $10 million and they go off and then sue me saying I failed to comply with the unilateral order, they not only would seek to recover all of their money spent, the $10 million, but they would seek treble damages, another $30 million, 3 times the cost of cleanup. So for an expensive site, could be a very large amount of money at risk if you refuse to comply with an order. So what happens is at most sites, private parties settle and they either agree to pay for and complete the response action under EPA direction or accept an order and go ahead and proceed in that fashion. This is kind of unusual in CERCLA. It's not common in federal statutes to have an entire section of the law, in this case, section 122 of the statute, but it provides a detailed set of provisions for how one might settle or, what rights you may have and what benefits you get from settling. It's all spelled out in the statute, which is pretty unusual.
So even though you've mentioned a few ways to settle, this seems like a harsh and one-sided system.
It is. But remember, CERCLA is designed to address contaminated sites that present a risk to human health and the environment. And the goal of the Congress was to do so quickly in order to protect the public. So it was set up that way because those are the goals that Congress established. Now, there are some ways that this sort of harsh system is mitigated. Mike talked about some of the defenses that have developed over the years, the original defenses and then the landowner defenses. Those have mitigated to some extent some of the harshness of the system. There's also an affirmative defense to liability in the United States. This concept of joint and several liability also has in tort law an analog known as the divisibility defense. And it also has been read into the statute by judicial interpretation. So under that theory, if there is a reasonable basis for apportionment among liable parties, then a private party might be able to reduce its liability to EPA. So simple example, hazardous substance is sent to a site by a party and their hazardous substance is present in the soil. But the groundwater is also contaminated at this site, but this particular hazardous substance adheres to the soil and doesn't get into the groundwater. The party could argue that their liability is divisible. It's limited to any cleanup associated with the soil, but since it's not in the groundwater that's been impacted by another party's hazardous substances, that's the other party's problem. It's divisible, it's divided between the parties who may have contributed to the soil, but whose substances did not make their way into the groundwater.
And if all of the PRPs are all liable, how are the cleanup costs allocated between them?
Picking up on what Sam was talking about just a moment ago, if you've got a multi-party site, if you've got a site that has 5 parties, EPA might decide at the outset that they're going to invite 3 of them to negotiate a settlement to do some part of that long process we talked about earlier, the remedial action process. Those 3 parties might decide, you know what, just to keep things simple, we're each going to pay a third of these upfront costs, and we'll figure it out later what to do about it. There is an industry built around allocating costs at Superfund sites for PRP groups. And the more complicated the site, the more expensive the allocation process can be. Some of the PRPs will be making divisibility arguments like Sam just described. Others will be making other arguments. They'll be saying, that party over there has been late to the table. They've ignored requests to do some work. They've not cooperated. They'll point to this other party and say that we have a groundwater remediation system here that costs $17 million because of that party's solvent waste. And again, they'll often with the help of third-party advisors, allocation experts. Each will probably have an attorney. Each may have an environmental consultant helping them make the arguments. But that's, at the end of the day, how these costs get split up. And, the way it gets done differs from site to site, but those are among the factors that get considered. EPA generally loves the idea of sophisticated PRP groups taking the lead and doing this themselves. And often EPA will help them by issuing a notice letter to PRP who's been recalcitrant. The process has evolved over the years, and it's rough justice at best, but it seems to work.
So let's say there are 500 parties, like you said, and they pick 3 with the deepest pockets. And then, like, maybe a party that was selected to bear the cost, can they sue a party that wasn't chosen and say, you should have been the one? Or can they argue that?
Absolutely. So this is obviously a key part of circle practice. In the context of the sort of PRP groups that Mike was primarily talking about, there can even be informal reach outs. So the 3 parties can say to a 4th party or to the 499th party, hey, you really should be part of our group. You need to join us because otherwise we're going to sue you later, or otherwise it's going to come after you, or whatever. And believe it or not, you might think, well, why would anyone say yes to that? But believe it or not, people actually do join. And there are lots of reasons why. But one of the reasons is there are a group of factors, generally speaking, are used to determine whether or not or how to do an allocation. The Gore and Torres factors. Gore factors, named after then Senator Al Gore, future Vice President Al Gore, and Torres, named after Judge Torres, who decided a famous case in the District of Rhode Island, the Smith case. And one of the factors is actually cooperation. And so if you are a cooperative party, your share should be lower than a party that is non-cooperative. So if you have 3 parties that are cooperating and you're the 4th party and they say, hey, come join us, you're taking a gamble if you say no. And there may be good reasons to say no, but you're taking a risk when you do that. So just to back up a little bit, a PRP can show that another entity is liable under CERCLA. Depending on the circumstances, it can absolutely bring that party into an action for cost recovery under Section 107 or for contribution under Section 113. And that is actually an important distinction that gets litigated quite a lot in the courts of appeal because there are different statutes of limitation, different burdens of proof, different requirements, like Wyoming has settled with the government for a Section 1 claim. Cost recovery is when a PRP wants to argue that the damages are divisible between parties and that the party making that argument, overpaid, while contribution is when the damages are not divisible, but costs still should be allocated to additional parties. It's also just worth noting that private cost recovery requires substantial compliance with the National Contingency Plan. And just to bring it back into where Mike left, very often this happens behind closed doors, happens in these long-term mediations that are called allocations. But sometimes it doesn't. Sometimes it does spill out into court. And so you do have a robust body of case law that helps both parties in court and parties in private PRP groups to argue our facts look like this case or that case. It's very fact dependent. And even the question of which factors apply in a case is extremely fact dependent.
Yes, and I would add that the district judge has a lot of discretion here to allocate among responsible parties. There are these factors, like the Gore factors and Torres and other courts have factors, but ultimately the district judge gets to decide if the case goes all the way to the end to trial, what parties' shares and how they should be allocated. So it gives the judge a lot of power in that regard. But the cooperation factor has definitely influenced a number of decisions by those district judges because they want to encourage and incentivize parties to participate. They want them to step up and not have to try every case. So the decisions reflect that courts do not want parties to sit in the weeds and try to avoid responsibility, but to step up. And if you don't, at the end of the day, if you go all the way to the end, the courts have been pretty harsh on those who try to do that.
That discretion is actually a great point. And that's part of the reason why people often do join PRP groups, because even joining an established PRP group, you are entitling yourself to a certain degree of control over what happens, the same type of control you have in any mediation. Whereas once you're before a district court judge who has discretion, who knows how it's going to come out.
I had a case where after argument, the judge told the parties that when he was a kid, he used to ride his bike past the Superfund site at issue. And we all thought, oh my gosh, what is this going to mean for our clients? Now, it didn't end up having a big impact, but the judge's discretion in Superfund cases, who they are, where they've come from, and what experiences they've had can all play into the decision process in a way that makes joining a PRP group seem more appealing.
Is this the same concept that having a prenup is better than the court deciding it for you? Like agreeing upon it within yourselves as the party is better?
Yeah, it depends what kind of risk tolerance you have. So if you agree, you know what you're going to get. If you go to court, you could be successful and not be responsible at all or a very small share. Or on the other hand, a judge could decide that the judge disagrees with your arguments and you could be left holding a much larger bag than you would have otherwise had to agree to.
Well, all this shuffling in general seems like it would take years. Is that accurate?
Well, Sam mentioned this is supposed to encourage quick cleanup. And I think one of the things that you hear very often as a knock on CERCLA is that it does take a long time. And I think when you're talking about, for example, a relatively contained site, like a landfill site where drums have been sent by a number of parties, those can actually move pretty quickly. And there's a little cottage industry, people who file lawsuits like that. In a major sediment Superfund site, in a major industrialized area, yeah, you're definitely talking about something that's going to take a long time, take years. And in some ways, that's a bad thing. It delays bringing that back to a useful purpose. But in some of the ways, it's really good because there are big leaps forward in remedial technology that happen at unexpected times. And developing these records, I mean, some of these sites go back to the 19th century, and develop the record to figure out who is responsible for what takes time and effort. So sometimes it does take years.
So let's move into discussing applications and implications. Jack, your answer is a great segue into talking about how these things take time, but also the technologies we use. And obviously, the statute has evolved since its inception. So could y'all expand on a couple different ways that it has evolved?
Sure, I'll suggest a couple of ways. One, we've mentioned this idea of enforcement first. Initially, when CERCLA was enacted, the government tried to bring actions in court to compel parties to perform cleanups. And those cases generally stalled. Parties would litigate and fight, and there were many, many defendants. And EPA realized that the better use of its powers was to use its 106 order authority. And when it did that, it broke the logjam and has been much more effective at bringing private parties into the fold to perform cleanups. From a more technical perspective, there's been a lot of lessons learned over the years on how to conduct cleanups, particularly at sites where we see the same kind of sites over and over again. So initially, a number of the sites that were being addressed would be former town dumps that would not have been lined. There were just holes in the ground where a lot of stuff, very technical term, would be thrown in there over the course of many decades. And so initially, a lot of time was spent studying each and every one of these to a fare thee well. But EPA realized, well, why don't we come up with some sort of standard remedies for different kinds of sites that we're seeing over and over again? And so they put out that as guidance. And so a landfill be one. Yes, there's a certain kind of cover we're going to put on those. We're going to monitor them. And those sorts of reforms were applied to other types of sites. And in that way, they were able to expedite the process. And so that was a pretty effective tool. I'd say the third thing, when I think about this, are all the statutory amendments that have been enacted over the years that we've alluded to mitigate joint and several liability, some of the unfairness in CERCLA. When a party took a particular action, it was perfectly lawful. They followed the rules. The regulations didn't prohibit whatever they did. But now CERCLA, after the fact, is saying you're responsible. And so there was certainly a lot of unhappiness in the industrial community about being held liable in that context. And so some of these statutory amendments over the years have been designed to promote or limit liability, whether you're a lender or an innocent landowner, a prospective purchaser. You get some relief from liability, and that also has led to some redevelopment of property that would have not otherwise been developed.
Thank you, Becca, on that a little bit. In the first Trump administration, a group of career EPA staff got together in a task force to try to look at common challenges they've been facing in the Superfund program over the years. And they came up with 50 some odd recommendations, ways to improve Superfund. And there are big things and little things about how remedy selection is going to get either referred to headquarters or not, that kind of thing. One of the principles that came out of that task force was a concept that EPA has been looking at some of these complicated sediment sites called adaptive management. It's basically engineering steroids. You look at a complex diagram, and the question is, when I turn the knob to the right, which way does the swing move? And same thing at a complex Superfund or sediment site. The idea would be that it's very complex. Let's try this little thing that looks like it won't hurt anything, and maybe that'll be all we need to do in that regard. We'll just keep an eye on it. So an adaptive site management has been one of the things that came out of the more recent improvements and enhancements to CERCLA.
Can you go over briefly about how CERCLA has been challenged in court?
I'd say there are two items that I'd flag in response to that. One is there have been quite a few court decisions that wrestled with the question of whether it was appropriate to impose retroactive liability under CERCLA, whether that is constitutional. Again, the notion is under CERCLA, passed in 1980, I did something in 1950, perfectly lawful at the time, followed all the rules, but now I'm being held responsible and incurring millions potentially in response costs. And so parties argued that's unfair, that's unconstitutional. You can't make me do something today for something that was completely lawful when I did it. And the courts have said, no, actually, the Congress can do that. There's some principles in the law about Congress having the ability to pass remedial statutes, and CERCLA falls within that category. I'd say the second sort of significant challenge in my mind to the statute relates to that 106 order authority that EPA has, the notion that they can order somebody to do something and you can't go to court. But if you refuse to comply, you risk enormous penalties and potential civil treble damages. It could be hundreds of millions of dollars depending upon the scope of the particular cleanup. And so the constitutionality of those order authorities have also been challenged. Most notably in the D.C. Circuit, there was a facial challenge to the 106 power, and it was rejected. Courts have upheld it, in part because CERCLA provides a provision that says, well, if you comply with an order, you can later go to the Environmental Appeals Board and seek reimbursement for any money that you spend. So that, in the world of due process, is considered a post-deprivation hearing, an opportunity to recover, and therefore this broad 106 power has been found to be constitutional.
One quick addition there, just a practice point. I think anybody who's practicing CERCLA, you have to learn quickly to check dates of the decisions you're looking at because courts have changed their view on things. For example, a number of circuits came up with the idea of a substantial continuation. So in an asset sale, generally speaking, you're not liable for liabilities. All you do is you purchase assets from another company, but there are exceptions, and substantial continuation
Was one of them. That has basically been retrenched by the circuit courts. So the moral is you have to be paying very close attention to the date of SARA, the date of particular Supreme Court and Circuit Court decisions, and you have to make sure that what you're seeing is still good law.
Thanks for expanding on that. Are there any opportunities for meaningful public involvement in CERCLA's processes?
The short answer is yes. There are actually many opportunities for meaningful public involvement. Congress provided those opportunities throughout the CERCLA process. NPL listing, for example, is a notice and comment rulemaking process. EPA selects a remedy at a particular site. The proposed plan will be subject to public comment. EPA also usually holds many public meetings about sites, both during the listing and after the listing process. And EPA, at least in my experience, EPA takes the comments that it gets at those meetings seriously. And of course, any consent decree that is entered into whether the government and a PRP or PRPs must first be published in the Federal Register for public comment or court review. Do want to note administrative settlements, ASAOCs, do not trigger notice and comment. But typically, what the government and parties can do in administrative settlements is narrower and provide less protection to the parties. And part of it is because the public is not involved. However, citizens' role is not unlimited. The public role is not unlimited. It cannot modify criteria. They cannot challenge the remedy in court until after the remedy is finished. And of course, there's a great example of that relatively recently in the Atlantic Richfield Supreme Court case. When can neighbors bring an action under state law? Of course, the court ruled that they had to wait until after the remedy was complete.
And so I know we touched on states a little bit earlier, and I'd like to chat about bringing things down to the state level a little bit more. What role can state or even local governments play in these processes beyond what is mandated? Can they set more stringent standards for their sites? Or I guess the CERCLA sites are federal, but can they get involved there at all?
The short answer is yes, they can. And we talked a little bit about more stringent state standards, the applicable or relevant or appropriate regulatory standards, the ARARs. Those can play a role in cleanup decisions. EPA has entered into memoranda of understanding with a number of states to coordinate mini Superfunds with the big Superfund, the comprehensive Superfund. And so those would be one way that state and local governments can take the lead at sites. EPA will often defer to state agencies to take the lead at a Superfund site. States are required to pay a 10% share of the response cost for sites that are in their jurisdiction. One thing we've seen quite a bit of is local governments often have in-kind services they can contribute to a cleanup. If you want to get sediment out of a river and dewater it somewhere, sometimes a municipality will have a nice piece of property they can let be used without rent. And we see that kind of thing happen. And those are a few ways that state and local governments can get involved, take it beyond the minimum. Jack already mentioned the role that tribes can play as natural resource trustees would be another example.
Wonderful. And how has environmental justice been implicated in CERCLA?
Well, it's been implicated in many ways. Of course, it depends a little bit on which administration or what administration is in power, both federal and state. Relatively recently, actually, in the first Trump administration, there was a publication that came out to discuss a number of Superfund sites that were in disadvantaged areas. The number was quite high in the 80% range. And so it's something that many people pay a lot of attention to, lots of agencies pay a lot of attention to. There was a period of time where every meeting I had with the government on CERCLA started with that question of, well, what about environmental justice? Now, that has changed. I don't expect it will come back at a federal level. I think perhaps more to the point, there are some specific examples of where environmental justice has been implicated. I've actually already talked about one in terms of Love Canal. There were widespread protests about what was going on, and that's part of the reason why there was so much attention on that site. Another example is in Warren County, North Carolina, in the late 1970s, early 1980s. The state government there decided to store truckloads of soil mixed with toxic PCBs in a rural, poor, overburdened community. And there were a series of protests that eventually led to the site being remediated. It was never formally a CERCLA site, the same concept. And so I think it's an important concept. It's something that we as practitioners have to look at, regardless of whether the administration is asking us to do so.
Thanks for expanding on that, Jack. So, what is one example of CERCLA being successful in its goal?
I've observed over the years that one thing that came out of CERCLA is the privatization of environmental stewardship. The notion that any transaction for real estate these days and many corporate mergers and acquisitions are accompanied by an environmental due diligence period. And if there's a problem, very often it gets cleaned up without the involvement of the government. The private sector has really taken this notion to heart, and it's quite frequently at the center of those discussions.
I'd say two things instead of one. One is sort of along the lines of Mike was saying, that the statute has been successful because looking at those initial goals, have cleanups occurred? Yes. Of the sites on the NPL, a very significant number have been addressed in a significant way as a result of CERCLA. And so EPA has been successful at addressing the most significant sites, although there are still many that remain. And secondly, imposing responsibility on private parties. The vast majority of cleanups are now performed by and paid for by private parties, not by the Superfund. And so in that way, I think, given Congress's dual goals, it's been a successful statute.
There's actually an entire section of the EPA website dedicated to CERCLA success stories. And it can be interesting to go and look at that. And what you'll see is everything from nature parks to business parks, land that has been restored to a useful purpose where before you wouldn't let your kids go anywhere near it. You can walk there, you can run there, you can shop there, you can business there. I think more fundamentally, CERCLA puts a premium on understanding what is at a site before you acquire it. That's really where this comes into play. And I think that what that means is that companies, entities, individuals who are buying property in industrial areas often tend to do a lot more research than maybe they once did before purchasing a site. That means that everybody has more information about what is there and what a site needs to potentially clean up and contamination.
And what are some notable recent or future developments to look out for regarding CERCLA?
Here in Washington, it seems appropriate to talk about what Congress is doing. In the last couple of years, Congress has reauthorized chemical feedstock tax, Sam mentioned earlier, and then in a subsequent piece of legislation, reauthorized the petroleum feedstock tax, which has generated a lot of money for Superfund responses. And in addition to that, Congress has made appropriations over the last several years to put more money into the Superfund, so much so that President Trump, the last couple of weeks, in his budget proposal, was proposed to take $250 million out of the appropriation for EPA next year because, quote unquote, they don't need it. They've got lots of money from these taxes.
So recent or future developments, two things come to mind. One is the expansion of the list of hazardous substances to include 2 PFAS compounds, PFOA and PFOS. That's potentially very significant. It's the first time that EPA has used this sort of direct authority to identify a hazardous substance under CERCLA in this way. But for sites that are already in the cleanup process, have gone through the cleanup, maybe they're in the long-term review process of managing a site, there's something called a 5-year review, which means every 5 years, EPA and the parties at issue at the site have to take another look to see whether the site is still protecting human health and the environment. So when you add in something like PFAS or these two compounds, that potentially could reopen a site and require additional remediation, which had not been contemplated by the parties originally. So that really could be significant. There's some litigation still pending regarding that listing, so we'll see exactly where that goes. The second thing that I think of is some renewed efforts in the Congress to provide another measure of relief. This relates to those PFAS issues, given the sort of ubiquitous nature of these compounds. There's been a push to provide a defense for, quote, passive receivers of PFAS from their CERCLA liability. So a bill was reintroduced this past February that has bipartisan support that would protect water treatment activities, public and private treatment works, drinking water systems, agriculture entities, state entities. The argument being that they didn't generate PFAS, they didn't use the PFAS, they simply received it passively. And as a result, they should not be exposed to what could be potentially very significant liability under CERCLA. And so that is legislation to keep an eye on. It might make its way through the Congress.
Wonderful. Thank you. And before we finish, are there any final thoughts or insights you'd like to share about CERCLA?
Well, I just want to say, I think this is a fascinating area of law and practice. There are lots of opportunities for creative thought, collaboration, litigation, all focused on the common goal of cleaning up sites, returning them to useful purpose.
I've been really impressed over the years with the intellect of the people that were working in this area. They were brilliant professionals at every turn. It's been wonderful making those friends and those contacts. And my wife doesn't like it too much when I take her to a Superfund site. And I've done it too many times probably to admit to. But this is some of the most beautiful land we've got in this country. I mean, some of these sites are really works of art. And it feels good having been part of making them not only beautiful, but protecting people from harm that might have lurked within.
Yeah, I think sort of echoing what I said earlier, I think while imperfect and sometimes harsh and unfair, it's been pretty successful at accomplishing the goals the Congress set out. Took a little while, but it has achieved quite effectively those initial goals of achieving cleanups and imposing responsibility on private parties.
Wonderful. Well, thank you all so much for joining. I certainly learned a lot about CERCLA, and it's great to hear more about the statute that protects us and protects our sites and helps them get back to normal so that the public can continue to enjoy them. So thank you so much for being on the podcast.
Thank you, Dara.
Thank you.
Thank you for having us.
This has been People, Places, Planet, and we'll see you in our next episode.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.